Having talked about the Council of Europe and specifically about the European Court of Human Rights, I now want to turn our attention to the European Union, which is of course much smaller than the Council of Europe, geography and population-wise, but it nonetheless plays a very important role within those 27 member states nowadays when it comes to issues, questions regarding human rights protection. And since it is not actually discussed very extensively in the textbook, I thought it would be important to add a few words here on how actually human rights came to be a part of the EU system, which very originally speaking, they were not. Furthermore, the way in which this is legally organized or basically legally achieved is somewhat particular and requires further explanation. And the starting point for this discussion is, of course, that the Treaty of Rome, which established the European Economic Community in 1957, was silent on the question of fundamental rights or human rights. But as economic integration progressed, it was only a matter of time until the question of human rights would arise, particularly because the European Court of Justice had decided that EU law would have a direct effect on the legal systems of the member states. And indeed, in the 1970s, a number of cases came up before the European Court of Justice, and I will not go into the details of them, in which it was confronted with such human rights implications. And the European Court of Justice found an interesting and, for the time being, compelling way out of it by saying that human rights were in fact a part of EU law through the constitutional traditions of the member states. So basically, indirectly, through the domestic legal systems, these rights were or had made their way into the EU legal order and were therefore having to be considered also by the Court of Justice. The court also pointed out that all the member states of the European Community were actually also a part of the European Convention on Human Rights. So also the convention, which as we know is a part of a different international organization, the Council of Europe, they were also to be considered relevant in the EC legal system. And this, for the time being at least back then, was an interesting and compelling way in which the European Court of Justice was able to take into account human rights, thereby also responding and sort of quieting pressures and criticism from national courts that were very worried that EC law with its direct effect could actually have negative impacts on the domestic protection of human rights. That said, as the EC became the European Union and its competencies and powers grew, it became increasingly clear that this was a crutch rather than a real sustainable solution. So in 1999, we finally have, on the political level, there being an agreement that we need a charter of EU fundamental rights, which was indeed passed in Nice in 2000. And this charter, which 7 years later became primary law and therefore basically equivalent to the treaties, to the foundational treaties of the EU, is divided into 6 chapters and offers a human rights catalogue, in the EU language a fundamental rights catalogue, that provides for the protection of these rights through EU institutions as well as through the member states when they are implementing EU law. And this last point is a very important one because it limits the application of the Charter only to those instances in which in fact EU law is at stake. So basically, you on the street being arrested for no reason by a police officer will not have any implications or will not raise any questions under the EU Charter because this has nothing to do with EU law or with the European Union in general. Rather, it is just within the purview and just within the powers of the member state in which this is happening that you're confronted with a violation. Still, given that there is the EU Charter and previously, of course, general principles of EU law through the constitutional traditions and through the conventions, the European Court of Justice, which is a very authoritative and powerful court at the regional level in Europe, does have jurisdiction on human rights matters. And this, of course, sometimes raises questions regarding the interplay between the European Court of Human Rights on the one hand and the European Court of Justice on the other hand. For example, is it lawful to return migrants under the EU Dublin regulation if in fact the receiving state is not providing adequate human rights protection? The two courts had different opinions on this. Given that the EU is nowadays involved in many different areas that go way beyond trade and even consumer protection, to also include environmental law, indeed refugee, asylum law, and even law enforcement and judicial cooperation, you can see how these matters and the interaction between these two courts is a topic that will remain very salient also in the future. Before ending this video, I would like to draw your attention to two more aspects. First, in 2007, the EU founded the Fundamental Rights Agency, which is indeed in charge of monitoring, supervising how human rights, fundamental rights are being protected in the EU under the Charter. And it's not just that this Vienna-based organization is very resourceful, which it is, but in its reports and surveys, it also draws on a very long tradition of the EU promoting in particular non-discrimination and equality rights. For example, when it comes to equal pay for women. And finally, questions of human rights received a lot of attention in the EU context recently when it came to Hungary and Poland, and especially to the kind of suspension mechanism that the EU had created under Article 7 of the Treaty of the European Union, which possibly provides for the suspension of voting rights if there is a persistent breach of core values of the EU, to which fundamental rights count, on the part of a member state. Article 7 refers hereby back to Article 2, which in fact enshrines various core values of the European Union as an institution, and you can see the text of this provision here next to me. And this also shows that the European Union has come a long way since 1957, when it was created as an exclusively economic organization that basically ignored questions regarding rights but other values such as the rule of law and democracy, to nowadays being an organization that actually does have those aspects, those values, those aspirations as a part of its goals. And given its tremendous resources and power, it will therefore play a vital role in determining the human rights future of Europe. This concludes the videos for this week, and I look forward to seeing you in class on Friday.